That doesn't look like me up there. Though maybe in a little bit of time. Well, I'll start talking and they'll get my slide up. There we go. Now, it's great to have an idea that you think is going to be the next best thing since sliced bread. But you have to keep in mind, as we've been hearing today, there are rules that must be followed to protect that invention. These rules work for you if you follow them, but they can work against you if you don't. This always reminds me of a time, right before Valentine's Day, when I went down to a small artisanal chocolate shop to buy the perfect chocolates. I got to talking to the owner, and when he found out I was an IP lawyer, he told me a trademark story about when he was first starting out in the business, and he developed this great chocolate bar, and he had this great name for it. So he makes thousands of these bars, he heads up to his first trade show, and he's going to sell the bars. Once he gets there, he sees down at the other end of the hall, there's another company, and it's got the same named chocolate bar, but they've been making this bar for years. So what happens? He ends up making a new name for the chocolate bars, taking the wrapper off all the bars, putting on new labels, and selling the bars under a different name. Now, this is an important trademark story on its own, but it also teaches us two valuable lessons for patents. One, you need to make sure that what you're actually doing is novel. You can't get a patent if you're doing something that's not new. Patent lawyers often do patentability studies to make sure what you're doing is novel. In other words, you're not inventing something that's already been invented before. Two, once you have an idea which you know is patentable, you need to stake your claim. Now, in the old days, you could work on your invention out in the garage in secret for years. And if someone filed a patent application that covered your invention, you could pull out your lab book, show you're working on the same concept before the other guy, and gain priority for your invention. And actually, we heard Chet just talk about how he filed the patent one day before the other guy, but he also had to show his lab book, show that he conceived of the invention before the other guy did. Now, this was considered to be more in tune with the American entrepreneurial spirit because it always awards the person that invented the thing first the patent. But things are different, and it doesn't work that way anymore. With the America Invents Act, the U.S. now joins the rest of the world as being a first-to-file country. Now, what does that mean? That means that while you're working in secret in your garage, if someone else files for a patent on the same invention, they're going to get the patent. It doesn't mean, however, that if someone sees your idea, they can sprint to the patent office and file for a patent on your invention. You still need to be the inventor of the patent. But if they come up with the same idea and beat you to the patent office, you're out of luck. Like if the other company had filed for their patent one day before Chet, they would have gotten the patent, even if he could show that he had invented the concept months before the other guys. The lesson we take from this is to file early. When you think you have an idea, you should file a patent application. We like to say, file early, file often. Now, if you're tight on cash, you may want to consider a provisional application. A provisional application is less expensive to prepare, you lock in your rights, and you have a year to file the regular application. The provisional application has two added benefits. One, it lets you say that your invention is patent pending, which is really helpful when you're trying to round up investors. Two, it gives you a year to see how things develop without having the pressure of someone else running to the patent office ahead of you. At the end of the year, you can evaluate whether to proceed with a regular patent application. You should keep in mind, though, that at the end of the day, provisionals only protect the inventions disclosed in them. Often, the drafting process of a regular patent application can help draw out additional aspects of the invention, some of which may be crucial or even turn out to be the only patentable part of the invention. Now, if you don't file a provisional or non-provisional application, just like under the patent law, once you disclose your invention in public, or you let the cat out of the bag, as we just heard, either by selling your invention or publishing an article, the clock starts. You've got 1 year to file a patent application before your own publication or sale prevents you from getting a patent. But be careful. If someone else was independently working on the same invention, they can dart to the patent office, file on their subject matter once they see that you're working on the same thing, and they can prevent you from getting a patent. Now, patents typically take a long time, often several years to get. But if you're in a rush, under the America Invents Act, you can request prioritized examination for an additional fee. Under the American Invents Act, once issued, patents can now be subject to two new types of post-grant opposition proceedings, inter partes review and post-grant review. What are these for? These are good if you're on the other side of the fence and you think a newly issued patent will be used against you. But they're both expensive to do. So stay on top of your invention. Recognize when you have something patentable and get a patent application, provisional or regular, on file.